Before we begin, a quick and important disclaimer. The information presented in this video is strictly for educational and entertainment purposes only and does not constitute professional, legal, financial, or psychological advice. Family law, custody guidelines, and divorce proceedings vary significantly by state, county, and jurisdiction. The historical trends, academic case studies, and sociological theories discussed throughout this presentation should not be interpreted as guaranteed legal outcomes or personalized counsel for your specific situation. Always conduct your own exhaustive due diligence and consult with a licensed family law attorney or qualified legal professional in your specific state before making any decisions regarding your personal legal matters. Picture a massive, echoing lecture hall at a prestigious American university. It is day one of Family Law 101, or perhaps an upper-level sociology seminar on the evolution of the modern American family. 300 eager students, the future judges, the future high-powered divorce attorneys, the future policymakers, and the future family therapists of this country, are sitting with their laptops open, ready to absorb the foundational text that will dictate their entire professional careers. The professor projects a series of slides on the board summarizing the economic, social, and emotional impacts of marital dissolution. The data presented is crisp, authoritative, and almost universally uniform in its narrative. It details the severe financial plunge women experience post-divorce. It highlights the vast emotional burden placed on custodial mothers. It outlines the societal safety nets required to catch families falling through the cracks of a broken home. But what about the men? If you look closely at the required reading, the dense $100 academic textbooks printed by major university presses, the peer-reviewed journals, the foundational legal casebooks, the narrative surrounding men in divorce is astonishingly quiet, or worse, distinctly singular and remarkably grim. Consider a heavily cited case study often found in these materials when discussing a family breakdown. The academic literature frequently categorizes the man into one of a few highly restrictive, deeply flawed archetypes. He is either the stoic, emotionally detached breadwinner who simply transfers his financial obligations via a state-mandated court order, the absentee father who voluntarily fades into the background of a bi-weekly weekend visitation schedule, or the contentious, bitter litigant fighting a scorched earth war over hidden assets and business valuations. There is a profound, echoing silence in the academic literature regarding the severe psychological trauma, the profound isolation, and the immense structural disadvantages men face when the very architecture of their lives is systematically dismantled. This is not just a minor oversight by a few disconnected professors. It is a deeply ingrained academic framework. The way divorce is taught in American universities directly shapes the implicit biases of the family court system. The textbooks these students read today become the closing arguments in a courtroom tomorrow. They become the baseline assumptions of court-appointed mediators. They become the default settings of psychological child custody evaluations. We are looking at a massive, well-funded system where the academic foundation itself may be fundamentally skewed, leaving millions of men walking into courtrooms completely unaware that the theoretical deck was stacked against them decades before they even filed the initial paperwork. Why does this matter to the average American man right now? Because the theoretical frameworks taught in sociology, psychology, and law schools absolutely do not stay trapped in the ivory tower. They bleed out into the real world, heavily influencing every single domestic relations case in the United States. Let us examine the history of the sociology of the family, as presented in mainstream academia. For decades, academic literature operated heavily on what researchers call the deficit model of fatherhood. When examining the dissolution of a nuclear family, academic studies historically measured a father's value almost exclusively through the lens of financial provision. If a father was removed from the daily household dynamic, textbooks historically framed the loss primarily as an economic deficit to the mother and the children. The intrinsic, emotional, psychological, and developmental value of the father was routinely marginalized in the literature. As a result, when these very students graduated and became lawmakers and judges, the legal standards they drafted, the very state statutes that govern alimony, child support, and custody today, were built upon this incredibly flawed academic premise. They were built on the textbook definition that a man's primary utility to his family is his wallet, and therefore, in the event of a divorce, the state's primary interest regarding the man is the efficient extraction and redistribution of that wealth. Furthermore, let us look at the psychology and social work textbooks detailing the emotional fallout of divorce. Academic chapters dedicated to post-divorce adjustment frequently emphasize the emotional resilience of women and the vast social support networks they cultivate. Conversely, the academic portrayal of men is often clinically reduced to bleak statistics on increased substance abuse, rapidly declining physical health, severe depression, and higher mortality rates. But these textbooks rarely dive into the systemic institutional reasons why these terrible outcomes occur. They rarely, if ever, critique the family court apparatus that systematically separates men from their children, forces them out of their homes, and strips away their generational wealth. Instead of analyzing the profound trauma of forced separation and the inherent bias of family courts as the direct causal factors, the academic literature often frames these tragic outcomes as personal moral failures or inherent male emotional illiteracy. This creates a highly dangerous, inescapable feedback loop. The textbooks state that men handle divorce poorly and become unstable. Therefore, judges who were trained on those textbooks view men as inherently less stable and subsequently restrict their custody, which in turn isolates the men further, directly causing the very instability the textbooks predicted. It is a devastating self-fulfilling prophecy written in academic ink. Today we are going to tear open the syllabus. We are going to conduct a meticulous, chapter-by-chapter forensic examination of how men are portrayed in the leading American academic textbooks on family law, sociology, and psychology. We are going to decode the specific language, the hidden academic biases, and the historical case studies that have built the modern divorce industry. For the American man who is currently contemplating divorce, actively navigating the wreckage of one, or simply trying to understand why the legal system feels so inherently cold, bureaucratic, and hostile, this is the exact problem we are going to solve for you today. We are not just going to complain about the system, we are going to expose its original academic blueprint. By the end of this deep dive, you will understand exactly where the mediators, the opposing counsel, and the judges get their baseline assumptions. You will learn the specific sociological theories like the maternal presumption doctrine and the historical evolution of the tender years doctrine, that, while supposedly theoretically abolished, still live like ghosts within the pages of modern legal textbooks and courtroom rulings. You will see how statistical data is often manipulated or selectively omitted in academic literature, to downplay the frequency of parental alienation and the absolute financial devastation experienced by divorced fathers. Most importantly, by deeply understanding the academic playbook used by the opposition, you will be equipped with the profound, structural knowledge required to navigate your own legal and emotional battles. You will know exactly what the system expects you to do, how it expects you to react, and how it has been academically trained from day one to view you. This is not about fighting blind anymore. This is about seeing the matrix of the family court system for exactly what it is, understanding the academic textbooks that coded it, and learning how historical trends and university case studies have systematically shaped the very real, very present reality of divorce for men in America today. Let us open one of the most widely assigned sociology texts used in American universities today to understand exactly how this reality is constructed. If you examine the foundational chapters on family dynamics, you will inevitably encounter the theory of structural functionalism. This mid-century academic framework, originally popularized by sociologists like Talcott Parsons, divided the nuclear family into two rigid, highly distinct spheres. Women were assigned the expressive role, meaning they were deemed the emotional, nurturing, and psychological center of the household. Men were strictly assigned the instrumental role, meaning their entire sociological value was reduced to external problem-solving and financial provision. Now, modern academic professors will quickly tell their students that sociology has evolved far past these archaic, rigid gender binaries. They will claim that the textbooks of 2026 reflect a highly progressive, egalitarian view of co-parenting. But if you look at the actual mechanics of how family law is applied in courtrooms today, you realize that the ghost of structural functionalism was never exorcised from the system. It was merely rebranded and codified into state law. Imagine if a man named Michael, a dedicated logistics manager living in Ohio in the year 2026, walks into a mandatory court-ordered mediation room. Michael has been an incredibly involved father since the day his children were born. He has packed the daily school lunches, he has managed the complex pediatric dental appointments, and he has spent countless hours coaching weekend youth sports. But the custody evaluator sitting across the table from him spent over 7 years in a university psychology program, internalizing the instrumental deficit model of fatherhood. Michael assumes he is walking into a neutral environment where he will be evaluated based on his actual, documented parenting merits. He is deeply mistaken. He is being evaluated against an academic archetype deeply embedded in the evaluator's subconscious. When Michael requests a pure 50-50 shared parenting schedule, The evaluator does not inherently view this as an act of profound paternal devotion. Instead, trained by textbooks that historically view men as secondary emotional figures, the evaluator is primed to view Michael as an instrumental provider who is suddenly, and somewhat suspiciously, trying to encroach on the expressive domain of the mother simply because a divorce petition was filed. The academic training leads the evaluator to heavily scrutinize Michael's motives, often interpreting his request for equal time as a hostile litigation tactic designed solely to lower his potential child support calculations. This is not a massive, malicious conspiracy coordinated by an individual evaluator. It is the direct, systemic, and unavoidable result of an educational curriculum that entirely failed to adequately theorize and respect the deeply emotional, primary nurturing capacity of fathers. To understand the sheer magnitude of this academic bias, we must thoroughly examine the historical trends surrounding the maternal presumption doctrine. For generations, American jurisprudence explicitly and legally dictated that children, particularly those in their early developmental stages, inherently and automatically belonged with their mothers. The textbooks utilized in law schools today frame the legislative abolishment of this specific doctrine in the late 20th century as a massive, sweeping triumph for gender equality within family courts. The academic narrative teaches young law students that the courts are now entirely blind to gender. But academic case studies analyzing actual judicial behavior and long-term custody outcomes reveal a much darker, incredibly stagnant reality. These deep dive studies show that while the explicit legal terminology was permanently erased from the state statutes, the underlying psychological assumption was merely repackaged for modern consumption. The controversial phrase tender years was simply swapped out for the seemingly neutral clinical phrase primary attachment figure. And who do the foundational developmental psychology textbooks almost universally identify as the default primary attachment figure in a household? The mother. Therefore, the system did not actually change its mechanics, it only changed its vocabulary. Consider the highly complex academic concept of maternal gatekeeping. Some advanced modern textbooks will briefly mention this sociological phenomenon, defining it as a dynamic where a mother actively restricts or marginalizes a father from participating in daily childcare responsibilities. However, you must pay intense attention to how the academic literature overwhelmingly frames and excuses this behavior. They frequently describe maternal gatekeeping not as a form of coercive control or parental alienation, but rather as a natural protective instinct, or an unavoidable result of the father allegedly lacking the necessary domestic skills. The textbook actively and consistently shifts the burden of blame for the exclusion directly onto the man being excluded. When an opposing attorney in 2026 aggressively cross-examines a father on the witness stand, they are utilizing this exact academic framing as a weapon. They will suggest to the judge that the father was historically uninvolved, pointing to the fact that the mother managed all the internal school portal communications. The father might desperately attempt to argue that the mother actively locked him out of those digital portals, changed the passwords, and categorically refused to share the educational schedule. But the judge, whose entire worldview was shaped by these specific academic texts, defaults to viewing the mother as the primary caregiver naturally managing her domain. The judge simultaneously defaults to viewing the father as a distant, complaining instrumental provider who is only now taking an active interest because the marriage is financially dissolving. Furthermore, we must conduct a forensic dive into the economic chapters of these university textbooks. When analyzing the financial aftermath of a marital dissolution, the university curriculum heavily and rightfully emphasizes the feminization of poverty. This highlights the severe economic drop women often face post-divorce. However, the textbook narrative almost universally stops dead right there. The academic literature exhibits an absolute blinding void when it comes to the extreme systemic financial destabilization of the divorced American male. These massive academic volumes detail the potential outcomes for women relying on single incomes, but they systematically and intentionally omit the devastating case studies of men who are ordered by the state to pay exorbitant, mathematically unsustainable spousal and child support awards based on theoretical imputed income, rather than their actual real-world take-home pay. The sociology professors do not detail the thousands of men who face actual physical incarceration via civil contempt orders because they physically cannot meet the astronomical financial demands dictated by a rigid spreadsheet formula created by state sociologists decades ago. They entirely fail to teach future lawmakers about the profound psychological trauma of a man having his wages aggressively garnished to the point of his own eviction, while simultaneously being legally mandated by the state to maintain a fully furnished 3-bedroom apartment for children, he is only legally permitted to see 4 days a month. By defining men strictly as disposable financial utilities and utterly ignoring their emotional and psychological destruction, the academic system paved the way for the most devastating, ruinous weapon ever utilized in modern family court proceedings. A weapon that takes the outdated concept of the instrumental provider and completely weaponizes it to financially suffocate and entirely bankrupt men before they ever even reach a final trial date. But to truly understand how this specific financial weapon is legally deployed and justified by the system, we have to flip ahead to the darkest, most highly guarded chapter in the family law casebooks, a chapter dealing with something legally referred to as pendant light orders, and precisely how the legal system systematically starves men out of their own defense funds. Let us dissect the concept of pendant light, a Latin legal phrase that translates directly to pending the litigation. In the dense, incredibly expensive family law casebooks assigned at Harvard, Yale, and every state university in between, pendant light orders are presented as a purely administrative, benign necessity. The academic textbooks argue that when a household inevitably splits, the family court must immediately establish a temporary financial baseline to prevent the immediate destitution of the dependent spouse and the children. On an academic chalkboard in a pristine lecture hall, this looks like a beautifully balanced, highly rational equation. The professor draws a neat diagram showing shared marital resources gracefully dividing to maintain the status quo until a final divorce decree can be legally negotiated. The academic literature frames this as a protective measure, a temporary bridge over troubled waters. But there is a massive, highly destructive chasm between the sterilized academic theory, taught to future judges, and the absolute financial carnage experienced by men in the real world. Imagine if a man named David, a mid-level systems analyst living in Atlanta, Georgia, in the year 2026, is suddenly served with divorce papers. Before David even has the opportunity to formally respond to the specific allegations outlined in the petition, his estranged wife's attorney files an emergency motion for pendant light support. Because the judge presiding over this emergency hearing was academically trained decades ago to view David almost exclusively through the sociological lens of the instrumental provider, the court immediately zeroes in on his gross income. The academic textbook theory of maintaining the status quo is instantly deployed. But what does status quo actually mean when translated from an academic textbook into a binding court order? Historically, and continuing into the present day, it heavily biases the lifestyle of the party who remains residing in the primary marital home. The judge signs a temporary pendant light order mandating that David must continue paying the mortgage on the 4-bedroom suburban house he is no longer legally allowed to sleep in. The order dictates he must continue paying the monthly utility bills, the car lease for his estranged wife, and the comprehensive family health insurance premiums. Furthermore, the state child support and temporary spousal support formulas, which were fundamentally built on outdated sociological models from the late 20th century, extract a massive percentage of his remaining net income. By the time the pendant light math is calculated, David is legally stripped of nearly his entire paycheck before it ever reaches his bank account. David is now left with perhaps 15 to 20% of his actual real-world take-home pay. Out of this tiny mathematically unlivable fraction, the legal system expects him to secure his own housing in a skyrocketing 2026 rental market, purchase his own groceries, pay for his own transportation, and somehow miraculously, afford a massive retainer for a competent family law attorney to defend himself in the actual upcoming final trial. This is the critical systemic flaw that the academic textbooks actively ignore and routinely fail to critique. By mathematically stripping the man of his liquid capital at the very inception of the legal process, the system effectively guarantees he cannot mount an adequate legal defense. The textbooks present pendant light as a pause button, but in reality, it is an aggressive, preemptive strike that financially starves the opposing side. It creates an incredibly asymmetric warfare scenario. The estranged wife is effectively utilizing David's own heavily garnished wages to fund her legal representation, while David is pushed toward extreme debt just to keep the lights on in a tiny studio apartment. When sociology professors teach family dynamics, they frequently omit the vast data sets showing how pendant light orders force thousands of men into immediate, crippling credit card debt or force them to liquidate their heavily penalized retirement accounts just to survive the temporary phase of their own divorce. Let us push this deep dive even further into the academic blind spots and examine a terrifying legal concept deeply embedded in these textbooks, known as imputed income. The academic theory taught in law schools assumes that individuals will inherently act in bad faith to protect their assets. Therefore, if a man experiences a sudden drop in income during the divorce process, the system is academically trained to be highly suspicious. Imagine David, collapsing under the extreme psychological stress of losing his daily access to his children and facing total financial ruin, loses his high-paying tech job. Or perhaps his industry simply experiences massive layoffs, a highly common reality in the 2026 economic landscape. The academic texts governing family law do not typically train judges to view this as a tragic, situational reality. Instead, the legal textbooks instruct the court to assume the man is intentionally underemployed to avoid his instrumental provider duties. The court will then utilize the academic doctrine of imputed income. The judge will look at David's historical earning capacity and legally demand that he continue paying support based on a salary that literally no longer exists. He is assessed taxes, child support, and alimony on phantom money. If he fails to pay this mathematically impossible sum, the arrearages compound with brutal interest. The textbooks categorize this as holding the obligor accountable. They frame it as protecting the best interests of the children, but they completely fail to document the potential outcomes of this draconian academic theory. They do not show the case studies of men facing actual physical incarceration via civil contempt orders because they cannot manifest money out of thin air. They do not teach the future lawyers about the profound, irreversible psychological devastation of being legally categorized as a deadbeat by a judge who is operating on a fundamentally flawed, academically sanctioned mathematical formula. The university presses continue to print these casebooks, entirely insulating the legal profession from the human cost of their theoretical models. They create a sterile bureaucratic environment where a man's entire life's work is reduced to a disposable income spreadsheet, totally devoid of empathy or contextual reality. The system systematically breaks him financially before he can ever present his case regarding his parental fitness. And if you think the financial extraction mechanisms detailed in the legal textbooks are brutal, you have not yet seen how the university psychology textbooks justify severing his biological and emotional connection to his children. To understand exactly how the system mentally breaks fathers, we must turn our attention to a deeply controversial, heavily protected psychiatric framework taught to every court-appointed therapist in the country, and we must uncover how academia actively trains custody evaluators to completely ignore the undeniable signs of parental alienation. When clinical psychology students and future social workers open their foundational texts regarding family systems, they are introduced to a highly sanitized, theoretically skewed version of high-conflict divorce. If you search the extensive indexes of these massive academic volumes for the specific term parental alienation, you will often find it entirely missing, relegated to a brief, dismissive footnote, or surrounded by heavily skeptical, qualifying language. For decades, the academic establishment has fiercely debated whether the systematic brainwashing of a child by one parent against the other even qualifies as a legitimate psychological syndrome. Because it lacks a standalone, definitive categorization in the most widely utilized psychiatric diagnostic manuals, university professors frequently instruct their graduate students to avoid the terminology entirely. Instead, the academic literature actively rebrands this profound psychological abuse under the broad, highly generalized umbrella of family systems theory. This specific academic framework dictates that in any family unit, all dysfunctions are inherently circular and co-created. The textbook theory insists that if a child is actively rejecting a parent, it cannot possibly be the unilateral fault of the other parent engaging in deliberate manipulation. The underlying academic assumption is that the rejected parent must have done something tangible to earn that rejection. This deeply flawed academic baseline completely erases the reality of coercive control. It trains future custody evaluators to look at a psychological hostage situation and automatically assume the hostage must have provoked the kidnapper. Imagine if a man named Robert, a high school science teacher living in Seattle, Washington, in the year 2026, steps into the sterile, overwhelmingly expensive office of a court-appointed psychological evaluator. Robert has not seen his 2 young daughters in 4 months. Prior to the sudden divorce filing, he was an integral, deeply loving fixture in their daily lives, helping with homework, managing bedtimes, and coaching their weekend activities. Now, during forced, highly scrutinized supervised visits, his daughters physically recoil from him. They use highly advanced, adult-level legal terminology to describe why they suddenly fear him, almost identically parroting the exact phrasing utilized in their mother's legal petitions. To anyone possessing basic common sense, this is a clear, undeniable case of psychological manipulation. But the evaluator sitting across the desk from Robert is not operating on common sense. They are operating strictly on the academic programming they received during their university training. When Robert desperately attempts to explain that his children are being actively manipulated, isolated, and alienated, the evaluator's academic training immediately flashes a massive clinical warning sign. The university textbooks have taught this evaluator that a father claiming parental alienation is often simply lacking clinical insight into his own profound parenting deficits. The academic literature instructs the therapist to view Robert's desperation not as the natural, agonizing panic of a devoted parent losing his children, but as a hostile, paranoid projection designed to deflect his own inadequacies. Let us examine the specific, highly clinical vocabulary the academic literature utilizes to mask and excuse this act of abuse. University textbooks frequently utilize terms like natural alignment, developmental affinity, or protective enmeshment to explain away a child's sudden, violent rejection of a historically loving father. The academic theory posits that during the extreme environmental stress of a marital dissolution, children will naturally cling to the perceived primary caregiver for survival. As we established in our review of sociological texts, the literature almost always defaults to assuming the mother is this primary figure. Therefore, when the mother actively disparages the father, blocks his phone calls, and the children subsequently absorb and reflect that hatred, the academic framework excuses the behavior as a natural survival mechanism or a temporary, stress-induced trauma bond. The textbook actively instructs the evaluator to completely ignore the toxic programming being inflicted by the mother, and instead focuses entirely, and hypercritically, on the father's reaction to being erased. Furthermore, the sociology and psychology curricula often frame the mother's alienating behavior through the lens of protective gatekeeping. The academic literature suggests that if the mother is limiting access, she must intuitively know something dangerous about the father that the court simply has not yet discovered. The burden of proof is completely and instantly inverted. Robert is now required to psychologically prove a negative. He must prove he is not a hidden danger, while the evaluator, strictly guided by their academic texts, heavily scrutinizes his every facial expression, tone of voice, and body language for signs of latent aggression. This creates what sociologists and behavioral psychologists refer to as a double bind, an impossible psychological trap, engineered entirely by the academic framework utilized in family courts. Because the textbooks dictate that parental alienation is highly controversial, or even go so far as to label it a dangerous myth propagated by abusive men seeking to maintain control, Robert is placed in a terrifying no-win scenario. If he aggressively fights the alienation in court, demanding more parenting time and requesting immediate psychological interventions for his children, the evaluator will document him as highly litigious, inherently hyper-controlling, and actively contributing to the children's emotional distress by refusing to respect their stated boundaries. The textbook automatically labels him a high-conflict personality type. Conversely, if Robert follows the widely distributed but devastatingly flawed advice to simply step back, give the children space, and wait patiently for them to naturally come around, the academic framework immediately views this through the historical deficit model of fatherhood. The evaluator will officially note in their final, binding report that Robert is emotionally detached, utterly disinterested in repairing the familial rupture, and is effectively voluntarily abandoning his parental role. The academic textbooks have systematically eliminated every possible correct response. They have constructed an invisible psychological maze where every single emotional reaction or strategic decision leads directly to the permanent, state-sanctioned loss of his children. The psychological destruction detailed in these clinical textbooks is entirely devastating, but it is only the setup for a much larger institutional strike. The custody evaluator's report, heavily biased by this skewed academic training and costing the father tens of thousands of borrowed dollars to procure, is eventually handed back to the judge. It becomes the foundational piece of scientific evidence that officially and permanently labels the father as a psychological risk to the family dynamic. But the legal system does not stop at merely limiting his custody based on these highly flawed clinical evaluations. The legal casebooks and the psychological diagnostic textbooks actually coordinate to provide the opposing counsel with a far more aggressive, immediate, and utterly inescapable legal weapon. Once the father is academically framed as an unstable, aggressive, or high-conflict threat to the family system, the academic literature provides the exact theoretical justification needed to physically remove him from his home, strip him of his civil liberties, and completely sever his contact with his children overnight. To understand exactly how the system seamlessly transitions from covert psychological manipulation to absolute physical state force, we must examine the most weaponized, highly abused legal maneuver in the modern family court playbook, a maneuver entirely justified by academic theories of power and control. The legal maneuver in question, heavily debated in academic circles but aggressively utilized in family courtrooms across the nation, is the ex parte temporary restraining order. To understand how a protective legal mechanism designed to shield genuine victims of physical abuse evolved into a routine, tactical weapon utilized to instantly evict fathers from their homes, we must trace its origins directly back to the university textbooks on sociology and gender studies. If you open any standard textbook dealing with domestic relations from the late 20th century to the present day, you will inevitably encounter a heavily cited sociological framework known as the Duluth model. This academic theory, visually represented by the power and control wheel, fundamentally reshaped how the American legal system views marital conflict. The academic literature surrounding this model dictates that domestic conflict is almost never a mutual breakdown of communication. Instead, the textbooks present a highly gendered paradigm where men are inherently viewed as the primary aggressors, utilizing various forms of intimidation, economic abuse, and emotional manipulation to maintain patriarchal dominance over women. While modern academic texts claim to have evolved past strict gender binaries, the operational reality within the court system remains firmly anchored to this original theory. The university curriculum explicitly trains future judges, magistrates, and law enforcement officers to view any allegation made by a wife through the lens of this presumptive victimhood, while simultaneously viewing the husband through the lens of presumptive guilt. Imagine if a man named Christopher, a dedicated senior architect living in Austin, Texas, in the year 2026, is navigating the early, highly stressful stages of a marital separation. There has been zero physical violence, zero threats, and entirely standard, albeit tense, verbal disagreements regarding the division of household finances. It is a Friday afternoon. Christopher is sitting at his kitchen table reviewing blueprints when a local sheriff's deputy knocks on the front door. The deputy hands Christopher a stack of legal documents and informs him that he has exactly 10 minutes to pack a single suitcase and vacate the premises. He is officially being served with an ex parte order of protection. Let us meticulously break down the terrifying legal mechanics of the ex parte process and how academia justifies it. The Latin term ex parte translates to from one party. It means that Christopher's estranged wife and her attorney went into a judge's chambers entirely in secret. Christopher was not notified. Christopher was not present. Christopher had absolutely no opportunity to defend himself, present his own evidence, or cross-examine his accuser. Based solely on a sworn affidavit, which in many modern cases only requires vague assertions of feeling intimidated or fearing potential future emotional distress, the judge signed an order immediately stripping Christopher of his constitutional right to his property and his fundamental right to access his children. How do the foundational legal casebooks justify bypassing the fundamental American legal tenet of due process? The academic justification is rooted entirely in the sociology of risk elimination. The textbooks instruct the judiciary that the potential danger to the perceived victim heavily outweighs the immediate civil rights of the accused. The academic framework demands that judges err on the side of caution, creating a systemic environment where temporary restraining orders are practically rubber-stamped. Professors of family law teach their students that these orders are merely temporary, asserting that the displaced man will eventually have his day in court a few weeks later. But the academic literature utterly fails to acknowledge the catastrophic, permanent tactical advantage this temporary maneuver provides to the opposing counsel. In the brutal reality of a 2026 family court proceeding, the ex parte order is colloquially known among aggressive litigators as the silver bullet. By successfully executing this maneuver, the opposing counsel accomplishes several devastating goals simultaneously. First, Christopher is instantly rendered homeless, forcing him into the chaotic, highly expensive scramble for emergency housing that we analyzed in our previous discussion on pendant light orders. Second, and far more insidiously, the mother instantly and unilaterally establishes herself as the sole custodial parent. She gains complete, undisturbed physical control over the children, the daily schedule, and the primary residence. When Christopher finally gets his mandated day in court 3 weeks later, the theoretical textbook promise of a fair hearing is a complete illusion. He is walking into that courtroom already carrying the heavy, stigmatizing label of an alleged abuser. The judge, whose entire academic background is steeped in the power and control wheel, views Christopher's mere presence with intense judicial suspicion. If the ex parte order is ultimately dropped due to a complete lack of evidence, the damage is already permanently codified into the timeline of the divorce. The opposing counsel will utilize those 3 weeks of forced separation to argue to the custody evaluator that the children have successfully adapted to a new, stable routine without their father. The academic principle of maintaining the status quo is abruptly weaponized against him. The very absence forced upon him by the state is used as the primary legal justification to permanently restrict his future parenting time. Historical trends and longitudinal case studies analyzing divorce filings over the past 3 decades reveal a staggering statistical anomaly. There is a massive, highly documented spike in domestic violence allegations and applications for restraining orders that coincide exactly with the filing of a divorce petition or the beginning of a custody dispute. Deep dive academic researchers are fully aware of this phenomenon. Some specialized legal journals even quietly categorize it as strategic litigation or tactical maneuvering. Yet, the mainstream textbooks utilized to train the thousands of family law practitioners across the United States systematically refuse to condemn this practice. They refuse to explicitly teach future officers of the court how to identify and severely penalize the fabrication of abuse for strategic leverage. By maintaining this deafening academic silence, the universities provide ongoing, tacit approval for the continued weaponization of the legal system against fathers. Christopher is now locked out of his home, alienated from his children, and financially bleeding from the temporary support orders. The system has successfully utilized academic theories of gendered violence to physically remove him from the board. But the extraction of his current resources is only the beginning of the academic blueprint. Once the man is physically displaced and painted as a psychological liability, the legal system turns its attention to his future. The true financial devastation does not simply calculate what he currently has in his bank account. It targets his potential. We must now open the highly complex economic chapters of these legal textbooks and examine how the system actively securitizes a man's future labor. We need to dissect the concept of human capital and exactly how the family court calculates the value of the invisible assets he has not even earned yet. To grasp this concept, we must delve into the macroeconomic chapters of modern family law casebooks, where the traditional definition of property is radically expanded. Historically, marital property was tangible. It was the physical house, the vehicles parked in the driveway, and the verified balance of a joint checking account. However, academic legal theorists in the late 20th century pushed for a vastly more abstract interpretation, heavily influenced by sociological partnership models. They successfully argued that the most valuable asset generated during a marriage is often not physical property, but rather enhanced earning capacity. This abstract concept is academically codified as human capital. In the sterile environment of a university lecture hall, professors teach future judges that an individual's specialized education, industry training, and professional network acquired or enhanced during the marriage represent a shared investment. Therefore, the academic consensus dictates that the future yield of that investment, the money a man will theoretically earn 5, 10, or 20 years after the divorce is finalized, is highly subject to present-day legal division. Imagine if a man named James, a senior machine learning engineer living in Chicago in the year 2026, finds himself sitting in a cold, windowless deposition room. Over the past decade, James worked punishing 80-hour weeks to climb the corporate ladder, surviving brutal tech industry layoffs and constantly studying advanced algorithms late into the night to maintain his competitive edge. His estranged wife is now petitioning the court for a permanent alimony structure. The academic framework utilized by her legal team does not view James as a human being facing extreme industry burnout. It views him as an incredibly lucrative, high-yield municipal bond. The opposing counsel hires an incredibly expensive vocational expert, a professional whose entire career is built upon the academic economic models taught in leading universities, to formally appraise James. This expert takes the stand and utilizes complex academic forecasting formulas, entirely detached from the volatile reality of the 2026 tech sector, to calculate the maximum potential earnings James could theoretically generate until the exact day of his retirement. The terrifying reality of this academic methodology is its inherent, foundational assumption of a perpetual uninterrupted upward economic trajectory. The university textbooks that train these vocational experts rely heavily on historical trends from the post-war economic boom, a time when a professional man joined a corporation and steadily rode an escalator of predictable promotions and annual raises until he received a pension. These academic models systematically fail to account for modern economic fragility. They do not factor in sudden industry collapses, severe physical illness, profound psychological burnout, or the massive wave of automated technology displacing highly skilled workers in the present day. The textbook formula simply draws a straight, aggressive line pointing upward. When the judge, operating on this deeply flawed academic foundation, issues the final decree, James is legally bound to distribute a massive percentage of this entirely theoretical future wealth. He is not paying based on what he actually has in his bank account today. He is paying a heavy mortgage on the ghost of his future labor. Let us deeply analyze the sociological partnership theory that academics routinely use to justify this staggering financial extraction. The university literature argues that marriage is a joint economic enterprise, remarkably akin to a corporate merger. If one partner handles the domestic sphere, the textbooks assert they have directly facilitated the other partner's ability to navigate the public economic sphere. While this sounds perfectly equitable in a theoretical academic vacuum, the practical application in a courtroom becomes highly asymmetrical and deeply punitive. Once the divorce is finalized, the joint enterprise is legally dissolved. Yet, the academic framework demands that the man continues to pay heavy dividends to his former partner based on his singular, ongoing, physical and mental labor. He must continue waking up at 5 in the morning, navigating a brutal daily commute, and absorbing immense corporate stress to fund a household he has been legally exiled from. The textbook theory of partnership permanently chains his future exertion to a relationship that no longer exists. Some critical legal scholars have quietly pointed out that this system mathematically resembles a sophisticated, state-sanctioned form of debt peonage, but such dissenting case studies are routinely marginalized or entirely excluded from the required reading lists of mainstream law schools. To fully understand the depth of this economic securitization, we must also look at how academic texts treat professional business owners. If a man owns a small plumbing business, a dental practice, or a freelance consultancy, the textbooks introduce the highly controversial concept of enterprise goodwill versus personal goodwill. The academic literature trains financial forensic accountants to place a massive monetary value on the man's personal reputation in the community. They calculate how much revenue his specific name and personal relationships generate, and they classify that abstract concept as a marital asset subject to division. He is effectively forced to buy back his own reputation from his estranged spouse. The court relies on university-backed formulas to assign a dollar amount to the sheer force of his personality and work ethic, completely ignoring the fact that if he suffers a massive health crisis the day after the trial, that goodwill instantly vanishes. The academic theory locks the valuation in stone, demanding hard currency for an invisible asset that only exists as long as the man continues to physically grind. Furthermore, the academic textbooks completely ignore the profound psychological destruction this mathematical securitization inflicts upon men. When a man realizes that every future promotion he earns, every overtime shift he volunteers for, and every late-night side project he launches will immediately trigger a legal motion to modify his support obligations upward, his fundamental ambition is systematically crushed. The academic literature fails to provide case studies on the thousands of divorced men who deliberately downshift their careers, refusing lucrative executive positions simply because the corresponding tax burden and increased spousal support extraction would leave them taking home less net income than they did at a much lower salary tier. The textbook models automatically categorize these men as intentionally underemployed or accuse them of hiding assets in bad faith, entirely failing to recognize the systemic, crushing disincentives the court itself has rigidly engineered. We are looking at a deeply entrenched academic paradigm that views men not as dynamic individuals navigating a complex, highly unstable modern economy, but as perpetual guaranteed revenue-generating machines. The universities have provided the opposing attorneys, the forensic accountants, and the judges with the exact mathematical formulas required to legally harvest a man's future energy before he has even had the opportunity to expend it. But understanding the theoretical math is only half of the equation. We must now turn our attention to the actual physical machinery of the state that enforces these academic formulas with terrifying precision. We need to follow the money completely outside the courtroom and uncover the massive, hidden financial incentives that actively reward the state government for maximizing every single dollar extracted from a divorced father. To fully comprehend why the system is so unyielding, we have to expose a deeply buried federal funding apparatus, and exactly how the academic textbooks conveniently omit the stark reality of Title 4D. If you examine the index of any standard family law textbook utilized in American law schools today, you might find a brief, highly sterilized paragraph detailing Title 4D of the Social Security Act. The academic literature typically frames this legislation, originally enacted in the late 20th century, as a righteous federal initiative designed to track down absent parents and recover funds to prevent single-parent households from relying entirely on state welfare systems. The universities teach this to future lawyers as a massive legislative triumph, a flawless mechanism of state-sponsored accountability. But what the academic textbooks fundamentally and intentionally omit is the catastrophic conflict of interest this legislation permanently injected directly into the veins of the family court system. By completely failing to teach the actual economic mechanics of Title 4D, academia has successfully hidden the fact that the family court is not a neutral arbiter of justice deciding the fate of a broken family. It is a highly incentivized, revenue-generating collection agency operating under the guise of domestic jurisprudence. To fully grasp the magnitude of this academic omission, we must break down exactly how this federal funding apparatus operates in the real world. Under Title 4D, the federal government provides massive financial incentives to state governments based entirely on their performance in establishing and collecting child support. For every single dollar a state successfully extracts from a divorced father, the federal government reimburses the state for a significant percentage of its administrative costs and provides additional performance-based financial bonuses. The math is incredibly simple and utterly devastating. The higher the child support orders a state judge issues, and the more aggressively the state enforcement agency collects that money, the more federal funding pours directly into the state treasury to balance municipal budgets, fund court expansions, and pay the salaries of the very administrators deciding the father's fate. Imagine if a man named Thomas, a highly skilled commercial electrician living in Columbus, Ohio, in the current year 2026, walks into family court. Thomas is a dedicated, completely capable father who has petitioned the court for a pure equal shared parenting schedule. He wants his children half the time, and he is fully prepared to provide a loving, stable home. From a purely sociological and developmental standpoint, decades of independent case studies prove that equal access to both capable parents yields the absolute best outcomes for children. Thomas logically assumes that the judge, acting as a neutral party, will recognize his fitness and grant the 50-50 split. But Thomas is completely unaware of the invisible economic machinery actively working against him. The judge presiding over his case operates within a court system that relies heavily on Title 4D federal matching funds. If the judge grants Thomas equal shared parenting, and both parents have relatively similar incomes, the required child support calculation effectively zeroes out. If Thomas pays $0 in child support, the state collects $0 through their centralized disbursement unit. If the state collects $0, their Title 4D performance metrics plummet, and the federal government withholds millions of dollars in financial bonuses. The academic textbooks utilized to train this judge completely fail to address this profound ethical nightmare. Instead, the law school curriculum provides the judge with sophisticated sociological theories and complex psychological justifications to deny Thomas his equal parenting time. The textbooks provide the academic cover required to mask a purely financial decision. By utilizing the archaic models of structural functionalism and the deficit model of fatherhood we analyzed earlier, the judge can intellectually justify labeling the mother as the primary caregiver. Once that subjective academic label is applied, the judge restricts Thomas to a standard every other weekend visitation schedule. This deliberate reduction in his parenting time legally justifies a massive maximum capacity child support order. Thomas believes he lost his children because of a flaw in his legal argument or a misinterpretation of his character. He does not realize he lost his children because his mandated financial extraction was required to satisfy a federal funding quota. Let us examine the specific vocabulary the academic literature utilizes to clinicalize and normalize this commercial transaction. When a father is processed through the Title 4D machinery, he is entirely stripped of his parental identity. The textbooks instruct law students and social workers to refer to the father not as a parent, but exclusively as the obligor. The mother is legally reclassified as the obligee. The children are reduced to the status of dependents. This is not simply a matter of legal semantics. It is a profound psychological tactic taught in universities to detach the human element from the process. By forcing the legal system to communicate entirely in the sterile language of commercial debt collection, The academic framework successfully neutralizes any empathy the court might feel for the father's emotional or financial destruction. It trains the enforcement agents to view Thomas not as a grieving father fighting to maintain a relationship with his children, but simply as a delinquent debtor failing to meet his commercial obligations to the state. Historical trends surrounding the enforcement of these orders reveal a system of state-sponsored coercion that borders on the absolute suspension of civil liberties. When Thomas inevitably struggles to pay the astronomically high, academically calculated support orders while simultaneously trying to maintain his own basic survival in the 2026 economy, the Title IV enforcement mechanisms activate. The textbooks frame these mechanisms as necessary compliance tools. In reality, they are tools of absolute systemic destruction. The state will immediately and automatically garnish his wages, intercept his tax returns, and freeze his bank accounts. If the arrearages compound, the state will suspend his commercial electrician license, actively destroying his only legal means of generating the very income they are demanding. They will suspend his driver license, ensuring he cannot physically commute to a job site or drive to see his children on his strictly limited visitation weekends. The academic literature defends these extreme measures by theorizing that they force compliance, completely ignoring the massive volume of real-world case studies demonstrating that destroying a man's ability to work practically guarantees permanent financial ruin and severely limits his potential to ever contribute to his children's lives again. The universities have engineered a perfectly closed, entirely self-sustaining loop. The sociology departments create the theories that devalue the father. The psychology departments create the diagnostic models that label him a risk. The law schools utilize these theories to build the legal framework that strips his custody and maximizes his financial extraction. And the Title IV federal funding apparatus provides the massive financial incentive for the state government to enforce this academic blueprint with ruthless, unyielding efficiency. The system does not just want his current assets or his future human capital. It fundamentally requires his forced marginalization to sustain its own economic survival. But to legally justify this absolute commercialization of the family unit, the academic system had to invent a universally accepted legal shield. They needed a phrase that sounds so inherently righteous, so deeply protective, that no politician, no voter, and no father could possibly question it without sounding like a monster. We must now turn to the most powerful, the most heavily weaponized, and the most dangerously subjective legal standard ever written into an American academic textbook. That standard is universally known throughout every single family law curriculum in the country as the best interests of the child. If you read the foundational textbooks on family jurisprudence, this legal doctrine is presented as the absolute pinnacle of ethical evolution in the American court system. Academic professors lecture their first-year law students that prior to the adoption of this standard, children were historically treated as mere property of the patriarch. The textbooks frame the best interest standard as a massive, enlightened paradigm shift, establishing the child as an independent human being whose ultimate well-being must legally supersede the desires of either parent. On a purely theoretical level, inside the sterile confines of a university lecture hall, it sounds utterly unassailable. Who could possibly argue against prioritizing the best interests of a child? It is a brilliant piece of linguistic engineering. The academic establishment created a legal doctrine that acts as a moral fortress, rendering any critique of the system incredibly difficult, because the system immediately accuses the critic of wanting to harm children. But when we transition from the academic theory to the brutal reality of a 2026 courtroom, this standard transforms from a protective shield into the most highly subjective, incredibly dangerous weapon actively deployed against fathers. To understand the sheer destructive power of this doctrine, we must conduct a forensic examination of how the academic literature completely fails to define it. Unlike tax law or contract law, where academic textbooks provide rigid mathematical formulas and highly specific definitions, the family law textbooks leave the best interests of the child almost entirely up to judicial discretion. The legal casebooks provide judges with a list of incredibly vague, highly malleable factors to consider, such as the emotional ties between the parent and child, the capacity of the parents to provide a stable environment, and the moral fitness of the parties involved. But the academic curriculum does not provide any objective, scientific metric to actually measure these abstract concepts. Because there is no objective academic standard, the judge and the court-appointed psychological evaluators are forced to rely entirely on their own subconscious biases. And as we have meticulously established in the previous sections, Their academic training has deeply programmed them with the deficit model of fatherhood and the maternal presumption doctrine. Therefore, when the legal system is mandated to determine the best interests of the child, the academic conditioning practically guarantees they will unconsciously define those interests as remaining primarily with the mother, while reducing the father to a visiting financial utility. Imagine if a man named William, a highly trained pediatric nurse working long shifts in Denver, Colorado, in the year 2026, finds himself embroiled in a highly contentious custody battle. William literally dedicated his entire professional life to the medical care and developmental well-being of children. His practical, real-world parenting resume is flawless. When William petitions the court for equal 50-50 shared custody, he presents an overwhelming mountain of evidence proving his exceptional capacity to nurture. He assumes the best interests of the child standard will clearly and objectively recognize his profound value as a primary caregiver. However, the opposing counsel, heavily trained in the strategic deployment of academic ambiguity, utilizes the extreme subjectivity of the standard to completely invert reality. They argue that William's demanding schedule as a pediatric nurse, the very profession that proves his dedication to children, actually makes him too busy to provide a stable routine. The textbook theory of stability is weaponized to penalize his labor. The opposing attorney argues that it is in the absolute best interests of the children to remain in their primary marital home with their mother to maintain their established routine, intentionally ignoring the fact that William was the one actively managing that routine prior to being forced out by a pendant light order. The academic textbooks justify this precise legal maneuvering through the concept of the primary caretaker. The literature instructs judges to heavily weigh which parent historically performed the majority of the invisible domestic labor, such as scheduling doctor appointments or buying clothes. But the academic framework completely ignores the systemic reality of modern marriages, where duties are often divided for economic efficiency. William may have been working grueling overtime shifts precisely to afford the house and the premium health insurance that allowed his wife to focus on the domestic scheduling. He sacrificed his time at home to guarantee their financial survival. Yet, under the highly skewed academic interpretation of the best interest standard, his massive economic sacrifice is not categorized as a supreme act of parental devotion. Instead, his resulting absence from certain domestic tasks is clinically documented as a lack of parental involvement. The university casebooks train the custody evaluator to look at William and conclude that because he did not personally fill out the school registration forms, transferring equal custody to him would disrupt the continuity of care, thereby violating the best interests of the child. The standard is infinitely flexible, allowing the system to retroactively categorize a father's greatest strengths as severe liabilities. We must also examine the highly lucrative secondary industry entirely sustained by this academic ambiguity. Because the best interest standard is so profoundly subjective, the court cannot simply make a ruling based on standard legal evidence. The textbooks dictate that the court must rely on a massive network of supposed experts. This includes the guardian ad litem, commonly referred to as a GAL, and the private custody evaluators we discussed previously. These professionals, armed with advanced degrees built upon these very same flawed academic textbooks, are granted terrifying, almost absolute power over the destiny of a family. They charge exorbitant hourly rates, sometimes stretching into the tens of thousands of dollars, to conduct highly invasive investigations into the father's life, all under the legal justification of discovering the child's best interests. Historical trends demonstrate that these court-appointed experts frequently lack specialized training in identifying covert psychological abuse or parental alienation, relying instead on the outdated, gendered models of structural functionalism taught in their university programs. They operate with almost zero institutional oversight, knowing that judges will almost universally adopt their recommendations to avoid the massive appellate risk of ruling against a court-appointed expert. The academic establishment has effectively created a system where the ultimate fate of a divorced father is outsourced to a highly paid, unregulated shadow court, operating behind closed doors. The university textbooks shield this shadow court from public scrutiny by draping it in the unassailable banner of child protection. For decades, men have walked into these evaluations believing they simply need to tell the truth and demonstrate their love. They completely fail to understand that they are walking into an academic trap designed specifically to pathologize their behavior, maximize the state's financial extraction, and permanently demote them to the status of a secondary visitor in their own children's lives. The best interests of the child standard is not a protective shield. It is the ultimate blank check, allowing the family court to enforce any historical bias, justify any financial ruin, and excuse any psychological destruction it deems necessary to maintain the machinery of the system. But the most terrifying aspect of this academic blueprint is not just how it calculates the loss of the children or the extraction of wealth. The true horror lies in the specific psychological tactics the textbooks recommend utilizing when a father actually attempts to fight back and demand his fundamental constitutional rights. To understand exactly how the system responds to a father who refuses to submit to the academic narrative, we have to examine the darkest, most highly guarded secret of the modern trial phase, and precisely how the courtroom strategically engineers a man's final public breaking point. If you open any advanced syllabus for a third-year law school seminar on trial advocacy, you will quickly realize that the modern American courtroom is not taught as a neutral forum for discovering the objective truth. It is taught as a highly controlled, deeply choreographed theater of psychological warfare. The academic textbooks detailing the rules of evidence and cross-examination do not instruct future family law attorneys to seek an amicable resolution. They instruct them to dismantle the opposition's credibility, character, and emotional stability in front of a judge. For a father fighting for his children, the trial phase is the ultimate crucible, an environment meticulously engineered by legal academics to validate the exact sociological biases and deficit models of fatherhood we have already exposed. The system has already starved the man financially through pendant light orders and isolated him psychologically through biased custody evaluations. Now, the academic blueprint dictates that the courtroom must serve as the anvil where his remaining resolve is publicly and permanently shattered. To understand the sheer cruelty of this academic design, we must examine the pedagogical strategies surrounding the cross-examination of a hostile witness. In clinical trial advocacy textbooks, law students are actively trained to utilize a psychological phenomenon known in psychiatric literature as reactive abuse, though the legal textbooks coldly rebrand it as impeaching the witness through demeanor. The academic strategy relies on the fact that the father is stepping into the courtroom in a state of profound, sustained trauma. He is exhausted, he is terrified of losing his children forever, and he is deeply wounded by months of state-sanctioned alienation. The textbook instructs the opposing counsel to weaponize that exact vulnerability. The goal is not to elicit facts. The goal is to continuously apply calculated, highly calibrated emotional pressure until the man inevitably cracks under the strain, thereby physically demonstrating the aggressive male stereotype the judge has been academically trained to expect. Imagine if a man named Mark, a highly disciplined commercial airline pilot living in Phoenix, Arizona, in the year 2026, takes the witness stand. For 20 years, Mark has successfully navigated multi-million-dollar aircraft through catastrophic weather systems with absolute ice-water composure. But the family court system does not care about his professional discipline. The opposing attorney, strictly following the academic playbook of trial advocacy, begins the cross-examination. The lawyer does not ask Mark about the countless hours he spent helping his children with their advanced mathematics homework. Instead, the lawyer utilizes the textbook technique of leading questions to isolate and completely decontextualize a single, frustrated text message Mark sent to his ex-wife 8 months ago during a heated argument about hidden marital funds. The academic literature on evidence strictly dictates how this trap is executed. The lawyer restricts Mark to simple yes or no answers, entirely stripping him of his voice and his ability to provide crucial context. When Mark naturally attempts to explain that the text message was a desperate response to discovering his life savings had been secretly drained, the attorney aggressively cuts him off. The lawyer turns to the judge, utilizing the academic rules of courtroom procedure to officially reprimand Mark for being non-responsive. The textbook strategy is to box the witness into a corner, making him feel entirely powerless, misunderstood, and actively silenced by the very institution that is supposed to be dispensing justice. This relentless, methodical provocation continues hour after hour. The lawyer sneers, utilizes a deeply condescending tone, and deliberately mischaracterizes Mark's deep love for his children as a pathological obsession with control, pulling terminology straight from the Duluth model textbooks. Eventually, the academic machinery achieves its primary objective. Mark, a man who has held his family together through immense sacrifice, experiences a totally natural human breaking point. His voice rises. He expresses righteous, entirely justified anger at the relentless stream of documented lies being presented as fact. He might point a finger, or his face might flush red with the sheer indignity of the spectacle. The instant Mark displays this negative emotion, The academic trap snaps shut with lethal precision. The opposing counsel immediately stops the questioning, allows a heavy silence to fall over the courtroom, and looks meaningfully at the judge. The textbook theory has been validated in real time. The judge, whose entire worldview was shaped by sociological texts warning of male volatility, does not view Mark's reaction as the agonizing cry of a loving father being systematically tortured by the state. The judge views it as empirical proof of an underlying anger management issue, cementing the narrative that Mark is a high-conflict individual incapable of co-parenting peacefully. We must also critically examine the legal concept of the cold record, a foundational principle taught in appellate law casebooks. When the trial concludes, the court reporter produces a written transcript of the proceedings. Academic textbooks teach that appellate courts will almost never overturn a trial judge's decision based on the credibility or demeanor of a witness, because the appellate judges were not physically present to observe the trial. They only have the cold record, but the transcript is entirely sterile. It does not record the opposing attorney's dripping sarcasm, the endless, agonizing pauses, or the strategic psychological bullying. It only records the actual words spoken. Therefore, when the transcript shows that Mark yelled or became combative, the cold record completely erases the state-sanctioned abuse that caused the reaction. The academic structure guarantees that the psychological violence inflicted upon the father is permanently deleted from history, while his desperate reaction to that violence becomes the undisputed, permanent legal truth utilized to strip him of his parental rights. Furthermore, the academic strategy of the trial phase extends far beyond the witness stand. We must look at the economic textbooks analyzing legal strategy and the concept of litigation attrition. Law schools teach future attorneys how to bury the opposition in an avalanche of procedural paperwork. They utilize massive, exhaustive discovery requests, demanding 10 years of highly obscure financial documents, banking ledgers, and personal correspondence. They file endless, frivolous motions to compel, forcing the father to pay his own attorney thousands of dollars simply to respond to legal harassment. The academic goal of litigation attrition is not to build a stronger factual case. It is to wage a war of economic exhaustion. The strategy is to systematically drain the father's pendant light depleted resources until he physically cannot afford to pay his lawyer to attend the final day of the trial. When a father eventually runs out of money and is forced to represent himself pro se in the year 2026, the academic textbooks practically guarantee his immediate slaughter. The rules of civil procedure and evidence are so highly complex, so deeply codified in archaic academic language, that a layman cannot possibly navigate them under extreme emotional duress. When Mark attempts to submit his own evidence proving his ex-wife's perjury, the opposing counsel will utilize textbook hearsay objections to have the evidence instantly thrown out. The judge will not assist Mark, because academic judicial ethics strictly prohibit the court from offering legal advice from the bench. Mark is forced to watch helplessly as his entire defense is systematically dismantled on procedural technicalities, entirely divorced from the actual truth of his family's reality. This is the darkest, most carefully protected secret of the academic legal curriculum. The system does not break men by accident. It breaks them because the university casebooks, the sociological theories, and the trial advocacy clinics were explicitly designed to prioritize procedural dominance over familial preservation. The textbooks have successfully engineered a completely closed, self-validating loop of destruction where the man's financial ruin is classified as equitable distribution, his psychological alienation is classified as protective gatekeeping, and his totally justified courtroom outrage is classified as proof of his unfitness. The gavel finally falls. The final decree is signed. The academic blueprint has been executed flawlessly. But the story does not end when the courtroom doors close. What happens on the first morning of the rest of his heavily restricted life? How does the state utilize the academic models of continuous enforcement to guarantee he remains a subservient, revenue-generating utility for the next 2 decades? And what are the specific unwritten strategies men are slowly developing to finally break the matrix of the modern family court? To answer that, we must first look at the morning after the final decree is signed. The courtroom theater has officially concluded, the judge has moved on to the next docket, and the opposing counsel has collected their massive retainer. But the academic machinery that engineered this outcome is far from finished. When a man wakes up on the first day of his legally restructured life, he often labors under the profound delusion that the battle is over and he can finally begin to rebuild. This is a critical misunderstanding of a foundational legal concept taught in every university family law clinic, known as continuous jurisdiction. The academic textbooks explicitly dictate that a family court case involving child support or alimony is never truly closed until the children reach the age of majority or the spousal support term strictly expires. The state retains absolute, ongoing authority over the man's financial destiny. He has not escaped the matrix. He has simply been permanently installed into it as a subservient, revenue-generating utility. Imagine if a man named Stephen, a highly skilled civil engineer living in Orlando, Florida, in the year 2026, has finally survived a brutal 2-year divorce process. Stephen is left with vastly reduced parenting time and a mathematically suffocating monthly support obligation. Through sheer resilience, Stephen decides to aggressively rebuild his life. He works late into the night, secures advanced engineering certifications, and 3 years later, he earns a massive promotion and a significant salary increase. Under standard capitalist theory, this is the reward for intense labor. But under the sociological and economic frameworks utilized in family court textbooks, Stephen's increased labor is immediately categorized as an exploitable resource. Within weeks of his promotion, his ex-wife's attorney files a legal petition for an upward modification of child support. The academic justification for this continuous financial extraction is known in the legal literature as the lifestyle equalization theory. The textbooks instruct judges that children have a fundamental right to share in the increased standard of living of the non-custodial parent, regardless of whether that wealth was generated entirely after the dissolution of the marital partnership. The court fundamentally ignores the fact that Stephen is working grueling hours specifically to recover from the devastating debt the court itself forced upon him via pendant light orders and legal fees. Instead, the judge, guided by these academic economic models, recalculates the formula. Stephen's hard-earned promotion is instantly heavily garnished. The system legally guarantees that any future success, any additional effort, and any attempt to elevate his own socioeconomic status will be immediately penalized and redistributed. This academic model creates a permanent state of economic hypervigilance, where men realize that their future earning capacity is permanently securitized by a system that views their labor as a public utility. However, historical trends over the past 5 years are revealing a massive, unprecedented shift in how men are responding to this systemic entrapment. We are witnessing the emergence of highly sophisticated, unwritten strategies as men slowly begin to decode the very academic textbooks that were used to dismantle them. The first and most critical strategy is the deployment of radical emotional detachment, a tactical response designed specifically to short-circuit the psychological warfare of the trial phase we analyzed earlier. Men are realizing that if the academic textbooks train custody evaluators and opposing attorneys to actively look for reactive abuse and male volatility, the only mathematical defense is to provide them with absolute, impenetrable stoicism. When a father in 2026 walks into a mandatory psychological evaluation or sits for a highly aggressive cross-examination, he is no longer walking in blind. He understands the Duluth model. He understands the deficit model of fatherhood. He knows exactly what the evaluator is academically trained to diagnose. Therefore, when the opposing counsel utilizes the textbook strategy of relentless provocation, deliberately mischaracterizing his love as control and his despair as aggression, the father refuses to supply the anticipated emotional reaction. He maintains a flat, highly professional effect. He answers strictly in concise, factual sentences. He completely starves the academic trap of the psychological fuel it requires to validate its own biased hypotheses. By actively refusing to become the hostile archetype the textbooks predict, men are forcing judges to look past the manufactured courtroom theater and examine the actual objective facts of the case. The second unwritten strategy involves a deep, systemic rejection of the high-conflict labels assigned by university psychology texts through the implementation of a highly rigid protocol known as parallel parenting. The academic literature historically penalizes men who attempt to aggressively enforce their parenting time by labeling them as litigious or domineering. To neutralize this, modern fathers are abandoning the theoretical ideal of amicable co-parenting with the hostile ex-spouse. Instead, they are completely bifurcating their communication. They utilize court-monitored digital applications exclusively. They communicate only regarding logistical facts, medical appointments, educational schedules, and emergency alerts. They refuse to engage in any emotional dialogue, completely eliminating the possibility of their text messages being strategically decontextualized in future court filings. By establishing this absolute, impenetrable boundary, They proactively destroy the opposing counsel's ability to manufacture the high-conflict narrative required to continually drag them back into the courtroom for future financial extractions. But the most profound strategy currently breaking the matrix is not happening inside the individual courtrooms. It is happening within state legislatures across the country, driven by a massive grassroots mobilization of fathers who have successfully reverse-engineered the academic playbook. By deeply studying the massive flaws in the subjective best interests of the child standard, these men are organizing to lobby for statutory changes that entirely bypass judicial bias. They are aggressively pushing for the legal codification of a rebuttable presumption of equal shared parenting. This means that instead of a judge starting with the academic assumption that the mother is the primary caregiver and the father is a visitor, the state law strictly dictates that the court must begin precisely at 50-50. The mathematical burden of proof is fundamentally inverted. The opposing counsel must now provide overwhelming, objective, scientific evidence of abuse or severe neglect to reduce a father's time below equal access. This legislative strategy directly attacks the academic monopoly, stripping the subjective power away from heavily biased custody evaluators and forcing the family court to operate on a baseline of guaranteed constitutional equality. The foundational pillars of the American academic family law curriculum are finally beginning to crack under the weight of independent, longitudinal case studies that conclusively prove children suffer catastrophic psychological, social, and economic damage when they are systematically alienated from their fathers. The deficit model of fatherhood is being mathematically and scientifically exposed as an ideological fraud. But the legal industrial complex, deeply addicted to Title IV funding, and the massive revenue streams generated by continuous jurisdiction, will not surrender its power willingly. The system will continue to utilize every psychological trap, every economic securitization formula, and every vague legal standard printed in those textbooks to maintain its absolute control over the American family. As we observe this massive paradigm shift unfolding in real time, a terrifying new variable is entering the equation, one that the academic theorists completely failed to predict when they designed this blueprint decades ago. What happens when the millions of children who were systematically stripped of their fathers by this very academic machinery finally reach adulthood, enter law schools, become legislators, and decide to turn their sights back on the multi-billion-dollar family court apparatus that actively engineered the destruction of their own childhoods?